Hello and a warm welcome to Federal Special Program Capital Beat. More than 5 years after being arrested in 2020 Delhi riots, larger conspiracy case, activist and former JNU students Umar Khalid and Sharjeel Imam continue to languish in Tihar Jail without trial or bail. Over the years, the courts from the lower to the High Court have continued to deny him bail, even though the Supreme Court has repeatedly said that the bail is the rule and jail is the exception. Now, for Khalid, accused of being the key conspirator in the Northeast Delhi riots of 2020 that left 53 people dead and hundreds injured, this was the sixth time that he was denied bail. The former JNU student leader has failed to get relief from the trial court thrice, twice from the Delhi High Court, and also withdrawn a bail plea from the Supreme Court. He's been charged under the stringent UAPA Act, which punishes the terror acts. Now, isn't this a travesty of justice? It almost looks like the justice is on trial. So, joining me this evening on this particular issue is a veteran Supreme Court lawyer and constitutional expert, Sanjay Hegde. Mr. Hegde, thank you so much for joining on the Federal. And your first thoughts, the manner in which, for the sixth time, the bail has been denied to Umar Khalid and Sharjeel Imam. What does one really say? One is at a loss of words.
Well, you're not the only one at a loss of words, but all of us are shocked. See, there was a feeling that Umar Khalid's matter was withdrawn from the Supreme Court, as you earlier said, just because we knew that a particular judge did not grant bail or it was unlikely. But to expect that somebody who was reasonably steeped in the professional values that we've all seen as lawyers would sign on to an order which is so heavily prosecution oriented, it gives us a shock. I'm almost reminded of an old video where I saw Soli Sorabji speaking about the ADM Jabalpur judgment during the emergency. He said, we were very sure of our Bombay boys, Chandrachud and Bhagwati. And when the judgment came, we were devastated. I now understand how it so happens that lawyers with similar values, when they turn judges, sometimes become more executive-minded than the executive itself.
But if you look at the proceedings yesterday, Justice Shailinder Kaur and Justice Naveen Chawla said that the pace of the trial will progress naturally. A hurried trial would be detrimental to the rights of both the appellants and the state. Now, what does it really mean if they are hinting at the fact that the trial will progress naturally? So does it mean that it's taken them 5 years to not grant bail? And then when they have to come to the larger conspiracy case, how many more years they will take? I really wanted to understand from you this particular line which they said.
I do not know why that was particularly relevant. Sometimes when judges decline bail, they say, okay, you speed up the trial. But when a judge declines bail, he or she does not say, take your own sweet time on going about things. You see, judges are guardians of our liberty. If they are casual about the liberty of even the most despicable of creatures, that only will proceed to being equally casual about your and my liberty.
But also what they added later on, they said that the parties have informed this court that the trial is currently at the stage of hearing arguments on the framing of charges. Thus, it indicates that the case is progressing. Now, how does one buy that argument? It takes 5 years, and we still say that the case is progressing, and what we say is that it's at the stage of hearing arguments on the framing of charges.
Well, that's a normal stage of trials. After the investigation, the police file a charge sheet. Then some witnesses are examined, and the court, based on the charge sheet and the material and the witnesses examined so far, figures out whether there is material to go on for a trial. It's also a stage where people can stand up and say, "Look, this is all that they've produced. There's nothing against me. Please discharge me from these proceedings." So, our arguments on framing of the charge are at that stage. And once charges are framed, then they're put to the accused. The accused has to plead guilty or not guilty and claim to be tried. And then the trial goes on. Now, this is the case, as the court itself notices, that the charge sheet is about 3,000 pages. And then there are, I think, 400 odd witnesses. So, trial in this case will take an unconscionably long time, and particularly in view of the fact that there must be at least about 40 or 50 accused in this. I'm not very sure of the number of accused in this case. They are all tied together under a supposed under an alleged story of conspiracy. What is the conspiracy? The conspiracy is that they organized the CAA protests and they continued it in order to embarrass the country at a time when President Trump was visiting. Now, if memory serves me right, the CAA protests actually began sometime around November, December
Yes.
of
November last week. Yes.
yes, of 2019.
Yes.
20 and it was allowed there was a blockade at Shaheen Bagh, and which went on and on till and at the same point of time there were the Delhi elections in February 2020. I do not think that by the time the CAA protests began, there was any whisper of any Trump visit.
Yes,
If
that's right.
memory serves me right, the Trump visit was a sudden visit uh, in February itself, which was announced in February itself. Before that, nobody had any inkling, not unless you were in the Indian Foreign Service and in the Foreign Office negotiating a presidential visit. These things happen these things have to be negotiated much in advance, and so I do not see anybody other than random activists who the investigations show as planning a huge, deep conspiracy. Now, all these are
Right.
matters of trial. Right now, you haven't even gone to the stage of framing of the charge.
Absolutely.
Is it the prosecution's case that you will keep them indefinitely in prison?
That's $1 million question, and it actually looks like that. But the court has observed that the role of Umar Khalid and Sharjeel Imam, basically in this entire conspiracy case, is grave. And for what they have delivered some inflammatory speeches on communal lines to instigate mass mobilization of members of the Muslim community. Now, what they have also observed, the court said, and prima facie, that Imam and Khalid were the first ones to act after the Citizenship Amendment Bill was passed by creating WhatsApp groups and distributing pamphlets in the Muslim populated areas calling for protests and chakka jams, including the disruption of essential supplies. Now, what I want to understand from you is that even if they have done this, uh, creating WhatsApp groups, calling people, and going in for a chakka jam, does it call for a case of UAPA actually?
Well, that's the problem with the UAPA. It was also the problem with TADA, POTA. The uh, application of its provisions is entirely without safeguards. If the police decides that they want to frame a UAPA case against you, they can just frame a case and then say that, you see, when so and so said Mary had a little lamb, its fleece was white as snow, then this was a coded message to for people who normally eat sheep to do X, Y, or Z. This is the kind of fairy tale logic which, if courts do not examine it prima facie, then we are all in deep trouble. If courts say no, 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 under this act, we in three judges of the Supreme Court have held that you cannot conduct a mini trial at the stage of bail, then I'm sorry, we are no more living in a country that has the fundamental right to assemble peaceably without arms.
Are the courts also not trying to take a very selective approach when it comes to giving paroles to people like Dera Sacha Soda chief? He's been given paroles how many times we do not know. I mean, you can just forget the number of times he's been given paroles. And then here you have a case where a young man is languishing in the court for what we do not know, no charges, nothing, except for some case which has been made out. So, what would you say to this selective approach, which is adopted by a few judges?
Listen, in defense of the courts, I must tell you that they have nothing to do with parole. Parole is an executive decision. It is a decision of the governments concerned that, look, as it is, our jails are crowded, as it is for reasons of housekeeping and all that, and keeping people reconciled to their sentences. At crucial points of time, you sometimes give them furlough. You go home and come back, or you give them parole to for a specific reason. Somebody is getting married, somebody is getting buried, and things like that. That is entirely an executive decision. But yes, an executive which so vigorously fights in court and says that let them rot in prison till the trial is completed is the same triple engine
Yes,
executive which goes around merrily distributing parole to its favored ones.
right. No, that is why, in fact, I asked you this question. But what do you think is going to be the pace? How many more years will Umar Khalid or Sharjeel Imam will have to wait? Is there anything which you can guess, or everything looks infinite at the moment?
Well, it's easy to be pessimistic, but there is always hope, and without hope, we cannot continue. But one thing is, just as people get the rulers they deserve, people also get the courts they deserve.
True.
And if courts are entitled to say, no, 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 I say so, then courts will also be unnecessarily mindful of the fact that they all come in with an inbuilt expiry date. They return to being ordinary citizens. And it is the citizens that they have judged who will be judging them. The judgment of history is harsh. Justice A.N. Ray, who led the bench on ADM Jabalpur, thereafter, when the tides changed, he could not really carry the court with him. There have been, in recent times also, judges who have flattered to deceive. I can only hope that we have judges who are essentially fair-minded. Forget everything else. You have had people like Rahul Pandita and Abhijit Iyer Mitra, who are not necessarily friendly to the opposition, who have also said that this is unfair. Sometimes I have this test which was given by Justice Kadju. I used to also prosecute. I used to be standing counsel for the state of Karnataka, if I got unreasonable on bail, he would look at me and say, "Bache ki jaan loge kya?" And that often is the principle. Even if you believe all that is alleged, 5 years without trial is grossly disproportionate.
Absolutely, and it amounts to like some more than 1814 days. But the basic rule, which every judge apparently has to look into, that the bail is rule and jail is an exception. Why is it so easily forgotten, Mr. Hegde? You've been dealing with so many cases, but normally when it comes to trials like these, this basic premise is mostly forgotten, and especially when you have cases where minorities are concerned, where political prisoners like these are concerned, and they are seen as people who are waging a war against the nation.
No, why do judges do it? It is because the law has that provision. And that provision has been applied in the UAPA. It has been applied in the PMLA, the ED cases, and it has applied in the drug cases, where the standard for bail has been set at that the judge should prima facie be satisfied that there is no case against you, you have not committed the crime, and that upon release that you will not commit relapse into crime. So the first thing, prima facie satisfaction. How do you go arrive at prima facie satisfaction? That is where all the nuts and bolts have been shut down by the Supreme Court in a judgment called Watali. Watali was a judgment arising from Jammu and Kashmir. Now you see, if you do not insist on the same rights throughout your country, irrespective of whether it is Kashmir or Kerala, whatever happens in Kashmir affects somebody in Kerala, somebody in Karnataka, somebody elsewhere. So, while the police can fix you in a drugs case, can fix you in maybe a money laundering case, the ED can fix you, or some of your statements, if they try in a UAPA case, then judges say, "Oh, this particular section is there," and so the axiom turns on its head. No, the normal rule is jail. Bail is granted in exceptional circumstances.
Hmm. No, but there is I mean, there's a feeling largely that, this case has been deliberately delayed, and maybe at the behest of some directions coming from the center. At least that's a perception. And why? Because I mean, if you look at the chronology of this entire case, the first bail which he got was rejected. I mean, sorry, the first bail which got rejected was in March 2022 by the Calcutta Duma Sessions Court. Then Delhi High Court, he then approached the Delhi High Court, which too denied any relief to him in October 2022. Then he filed a bail plea in the Supreme Court. And after Delhi police was given 2 months to file the reply. And after 2 months, when it came up in July 2023, Delhi police sought adjournment. Then at that time also, Kapil Sibal had protested, "It's 2 years now. Why is a reply even needed in a bail matter?" And judges brushed it off, adjourned the matter, saying it may take 1 or 2 minutes only. That was what they said. And then later on, this entire case went to Bela Trivedi. And there we saw some 14 adjournments in 11 months. Now, if you look at this chronology, 14th February, May 2024, July 2024, we do not understand this sequence. Does it really show that deliberately it has been delayed, sir?
See, if bail is denied by the Supreme Court, then doors are shut for a very long time. Okay. People who operate in the Supreme Court have to operate almost under the Hippocratic Oath. First, do no harm. The judge who said that it might take 1 or 2 minutes, unfortunately suffered a heart attack. Did not return to the bench. Did not return to the bench for some time and came back just short of his retirement. Then, of course, it went to the other judge you mentioned. And it was a determination of the council, after taking instructions from clients, that you do not press the matter here, and sort of withdraw. Now, you said that there were 11 adjournments. Most of the adjournments, let's be fair to the system, most of the adjournments were taken citing one reason or the other, hoping that the system righted itself. The system didn't right itself. The system didn't right itself, or that was the determination of council, and that's why they withdrew. So then again, once a withdrawn petition goes to the trial courts, it is uh, it's a rare trial court which would actually grant bail, especially with the strict conditions under UAPA.
But
But
my last,
but
sorry,
just 1 minute.
yeah.
High courts and Supreme Courts are constitutional courts. They are courts with immunity. They are given fixity of tenure, and they cannot be removed from office except in very stringent circumstances. Our constitution makers and the people of India gave this power and this saving immunity clause to judges for a reason, so that when unreasonable men or women took over the executive, the judges could still make them see reason.
But isn't it a travesty of justice, almost like justice itself is put on a trial? And this is my last question to you, Mr. Hegde.
There was a sessions judge called, I think, GP Tareja, who said that in a courtroom, both sides know the truth. It's only the judge who's on trial. And judges often are as much on trial as those that they judge. That's why there is even a proverb in the Bible, if I'm not mistaken: judge not, lest ye be judged. But we in the profession firmly believe that our judges, who have risen from among us, perform a sacred duty, a duty to be fair, a duty to stand up for the rights of the citizen. And when they do not stand up for the rights of any one particular class of citizen, then the judgment of many people will be that uh, they have been party to injustice.
Well, it's a long battle, I think, which Umar Khalid and Sharjeel Imam has to face, and let's see how and when they get the bail. Thank you so much, Mr. Hegde, for joining on the Federal. Thank you, sir.